Hi, this is Professor Thaddeus Pope with a brief video about a new conflict about brain death. The case is Whitehead versus Buffalo General Hospital in the Supreme Court of New York, Erie County. So this is a New York case. The patient is Beverly Whitehead. She's 62 years old. She has 3 children and 7 grandchildren. She's been a long time administrator at this local Buffalo area college. And on March 26th, just a few weeks ago, she was at this Buffalo area casino when she suffered a cardiac event. She was then transported to Buffalo General Hospital. The next day, March 27th, clinicians suspected that she might be brain dead on neurologic criteria because she was comatose and unresponsive. So on March 30th, Lucy Campbell, the ICU director at Buffalo General Hospital, conducts a brain death exam. She does that exam. She follows the checklist that Buffalo General and the Cty Health System use, goes through the checklist, and then confirms that, in fact, Beverly Whitehead is dead. 2 days later, April 2nd, 2022, Jamie Nadler, also a critical care physician and the director of patient safety at Buffalo General, conducts a second brain death exam, also confirms that Beverly Whitehead is dead. So brain death was determined twice, on March 30th and then again on April 2nd. But today, and I'm recording this on May 17th, Beverly Whitehead is still in the ICU at Buffalo General Hospital. That's 46 days later, right? Quite a long time. It's unusual for any patient to be in the ICU that long. Definitely not somebody after being determined dead. Why is she still there? Because the local court has ordered that. The court says Buffalo General Hospital, its agents, employees, doctors, nurses, and staff are restrained from withdrawing life support from Beverly Whitehead. Why the court order? Because the family, these are Beverly Whitehead's 3 children, petitioned for that. They want a second opinion. They don't accept the diagnosis from Buffalo General. If we're counting accurately, this would actually be a 4th opinion. Remember, Dr. Campbell performed the first brain death exam on March 30th, Dr. Nadler the second one on April 2nd, and then Buffalo General reached out to Colm Amory, who is a neurologist at Albany Medical Center, who provided a 3rd opinion. He looked at the exams and evaluations and said that she is brain dead. But what the family wants is an independent opinion, a neutral opinion, somebody detached, separate from Buffalo General. In fact, separate, independent from the entire Cty Health System. So the family selected William Copland, who's a neurocritical care intensivist, and he is at Mercy Hospital of Buffalo, which is part of the Catholic health system. So he meets this, what the family's looking for, which is somebody who's independent from the current treating provider. But the flip side of that is that he doesn't have privileges at Buffalo General or with the Cty system. And that credentialing process does take some time, right? As I said, she's been there for 46 days after being determined dead on neurologic criteria. In the last few days, the family has actually made some new arguments to the court. One is that she's not dead medically. And specifically, the point is that her ventilator was set at 20, and they took a picture of the ventilator going to 21 and say, look, that's her, right? That means she's breathing, right? That's her breath. And if that's true, then that would mean that she's not dead, because a patient who can breathe on her own is not dead. The second argument is that she's not dead legally. This argument relies upon expert evidence from Paul Byrne, who has appeared perhaps in the vast majority of all brain death conflicts that have escalated to court all across the United States over the past 10 years or so. Byrne says, look, her hypothalamus is still functioning, therefore she's not dead under New York law. This argument may actually have some legs. New York law does say that you're not dead on neurologic criteria, you're not brain dead until there's irreversible cessation of all functions of the entire brain. The American Academy of Neurology, the authors of the most authoritative criteria for diagnosing brain death in adults, issued a position statement 3 years ago. In that statement, the AAN says that a patient can satisfy brain death guidelines, so they're dead. Yet, neuroendocrine function may be present. What the AAN is saying is clinicians may determine brain death despite ongoing function of the hypothalamus, which is what Byrne is saying happened here. And the AAN says that that's not inconsistent with the whole brain standard of death, except that it is. The law in New York, which is the same as the law everywhere else in the United States, requires irreversible cessation of all functions of the entire brain. And the hypothalamus is part of the brain. There is a gap between the medical criteria and the legal standard. And this has happened in previous court cases, perhaps most famously in the Jahai McMath case. The original attack in that case, as in this case, was that Jahai doesn't satisfy brain death criteria. Right? So we could apply the criteria, she doesn't meet them. But the later challenge in that case is after the guidelines themselves, the attack to the guidelines themselves, and what the plaintiffs said, Jahai's family's lawyers, is they wanted the opportunity to present evidence and expert testimony that the AAN guidelines fail to meet the requirements of the California Uniform Determination of Death Act, that an individual is brain dead only after suffering irreversible cessation of all functions of the entire brain. Now, the McMath case settled before the court could adjudicate on that question, but it is, in fact, a central motivating concern for the Uniform Law Commission to revise the Uniform Determination of Death Act to close or bridge this gap between the medical criteria for determining brain death and the law and the legal standards for determining brain death. So we'll see what happens next in this ongoing lawsuit in Buffalo, New York. I'm Thaddeus Pope, a law professor at Mitchell Hamlin School of Law in St. Paul, Minnesota. Thank you.